noise. So welcome everybody. Judge Williams and I really want to thank you for attending on a Friday afternoon of a long holiday weekend that is above and beyond the call of duty. We are going to try to keep this as close to an hour as we can. So to the extent that as people report out, I do plan to ask if people have any immediate questions or comments, but feel free to give some thought to what you're hearing and then contact the chairs directly to the extent you do have additional questions or comments. All right, everybody should have the agenda. The first thing we need to do is approve the minutes. I'm going to sort of cut through it. Is there any discussion, or can they be approved? Hearing nothing, the minutes from July 14th are approved. I wanted to just remind you all, because now you've had at least, I believe, 2 meetings, every one of the groups, that we had intended a December deadline to coincide with the legislative session, so that whatever you all come out with that is ultimately approved by the Chief Justice, we can get it before the legislature to the extent there should be statutory changes. Does anybody have any immediate concerns at this point that that's not going to be doable for a particular area that you're looking at? All right, again, I'm not hearing anything, but to the extent that is an issue, if you could contact Judge Williams or myself to talk about it, and we'll figure out what the next step will be then on that issue. In that regard, to the extent that you're proposing some legislation, it would be extremely helpful if you could have some rough language as to what that should look like. External Affairs obviously will work on it. They probably, I hadn't thought of this before, but they probably are available to you. I'm probably going to get in trouble now, but they probably are available to you before, to the extent that you have some questions as to what it should look like, and that would be Melissa Farley, who you would want to talk to about that. But you should just go through your administrative person for your particular group. So with that, we really want to thank you in advance for all the work that you've been doing. We can tell from the questions that we've been getting, and also some informal updates that we've been getting, that you all are thinking deeply about these issues and that you're working hard on them. So again, thank you on behalf of ourselves and the Chief Justice. I think we can start with the Data, Statutes, and Rules Subcommittee. Dean Fisher and Attorney Howard, if you could report out so that people on the committee generally have an idea of where you are going.
Hi, everyone. So I'm Claire Howard. My co-chair, Dean Fisher, is actually in Maine on vacation. And unfortunately, where he is in Maine, there is no reliable internet or cell phone service. So, he sends his regrets, and he and I have talked, so we have both are on the same page in terms of the update that I'm going to provide right now. So in terms of our subcommittee's charge, we really started with just reviewing that, so that we were all on the same page in terms of, our main charge was to review the statutory authority and practice book rules governing the confirmation process, the questionnaire, and to look at the juror demographic information that's currently collected and what should be actually collected. And, as part of doing that, also looking at what other states are also doing for data collection. And so what we did with our first meetings, we started really with the big picture in terms of what data is collected, what statutes and practice book provisions exist. And from there, we really started to look at what do we want our end product to look like? What do we want the subcommittee to create? And what would those recommendations really look like? And so we started talking about collecting data on juror selection, juror demographics, what kind of statutory and rule changes we would want to have to allow for greater access to this data. Because it's not just enough to collect data, but we also have to make sure that it's available for researchers and also to actually, available for appeals or for whatever purpose. So, it's not just the data, but also how do we change statutes and practice book provisions to make sure it's available and what should be available. And so we've had a lot of discussions around that. And so far we've met about 3 times. And we also participated in a presentation by Professor Sachin Pandya, who's a professor at UConn School of Law, who is creating, or actually has created, an algorithm that looks at criminal jury data. He was looking specifically at data from the District of Connecticut, because that was more readily accessible. And he looked at attorney preemptions of jurors, and the algorithm used data around preemptions and the juror's race to try to predict, and I'm going to try to predict the bias of the attorney going forward. And I use that word not quite literally. So he really uses the word bias to, more as a general sort of catch-all to predict the behavior, I would say, more of the attorney in terms of the choices they'll likely make in the future. And the more data he has on it, the more better of a prediction it actually ends up happening. And so right now he's kind of using the limited data within the District of Connecticut. And so we've had some conversations with him about, were we to suggest more robust data, how would that inform your algorithm? And I think for all of our committee members sitting through the presentation, and I think also for Tim and I, it's really helped us think about, in a really kind of concrete fashion, what sort of data should be collected, because it will likely be used by researchers, including Professor Pandya. So that's also been very helpful for us in terms of us thinking in a more concrete way and getting to specific areas of consensus. And so thus far, the areas of consensus that we've been able to reach as a subcommittee are really that the current question on the juror questionnaire about race should be made mandatory instead of optional. Currently it's optional. And there's no real statistics gathered on how often jurors complete that optional question, but we believe by at least saying that it's mandatory, that will increase the percentage of jurors that actually say how they self-identify. So that's one area of consensus we've been able to reach. We've also talked about personally identifiable information regarding jurors and making sure that it's still only available. So currently, in terms of the statutes, it's only available for 21 days after the case for purposes of an appeal on, say, a Batson challenge. And so we want to keep that the same way. We don't want to change it. We don't want to make personally identifiable information about jurors available for a longer period. However, we've talked about making sure that data that is not personally identifiable is available for an indefinite period of time. And so we're still parsing out what that looks like, in terms of on a practical level, but we really think that personally identifiable information really should stay the way it is, 21 days after the case is concluded, non-personally identifiable information available to the public and available indefinitely. Some of the issues that we're currently exploring that we haven't quite reached consensus, but we're still kind of discussing, and I think will help inform our recommendations that we make, include kind of looking at what other states are doing in terms of data collection and the statutory language guiding the data collection on jurors. And Chris Pleasanton and Frank Rizzo have done a great job of starting to look at what other states are doing. They found that in Nebraska, New York, and Pennsylvania, they all collect data on the race of jurors on the questionnaire. And so I think in particular in Pennsylvania, their Rule 632 has a copy of their questionnaire. So we're going to start, to the extent possible, looking at specific questionnaires and specific rules and specific statutes that we can really particularly start getting to the nuts and bolts with our recommendations. And I think, to the extent that we're able to have specific language in our recommendations for what the statutory changes look like, we'll definitely make sure we do that. We've also talked about how to frame race identification questions on the juror questionnaires to make sure that we're encouraging compliance. Because, on a practical level, even if we make the race, the self-identification questions regarding race mandatory, on a practical level, what we understand is that judges are not going to exclude a juror just because they didn't identify their race on the form. And so we're trying to make sure that we structure it in a way that encourages as many jurors to do it. And so we've also talked about making sure that we're aware that in the kind of self-identification boxes that are included under race, that we make sure it's refined enough to really capture all the various ways that people self-identify, including people that may self-identify as belonging to more than one racial category. And so we'll likely be looking at the US Census and their sort of recommendations for how to make sure we include every single category possible and make it clear that to jurors that they're not limited to just one particular category. They can kind of check off all the specific racial categories that they self-identify as. And I think that'll also allow for a much clearer, crisper picture for juror participation, juror nullification, and that sort of thing. So those are things that we're still kind of tackling that we haven't got into a consensus or kind of refined yet. But I think in the next couple of weeks, we'll probably get to specifics on. Some of the other issues that we're talking about that, we'd love to get feedback from, and please feel free to email Tim and/or I after this presentation about these particular issues, is we're still looking at recommendations regarding collecting information on over the overall jury veneer. So who is selected for the jury pool, and that may allow researchers to make comparisons between the panel that's actually selected and the pool that that is started with. And so, we're still kind of talking about it as a subcommittee. We haven't really reached, I think, a clear sort of consensus on this. And as I said, because this in particular overlaps with some of the work that some of the other subcommittees are doing, after this, if anyone has thoughts, please feel free to email Tim and I on that in terms of how jury veneer information should be collected. And of course, we don't, like I said, we don't want to bump up against any of the other work that any of the other subcommittees are doing. The other second area that we're still talking about, and I'd love to get feedback from other subcommittee members or chairs on, is in terms of gathering information about other protected categories for which Batson protections may have been afforded, like gender or ethnicity, such as Hispanic. And so, we've talked about making sure that we keep a focus on building the data capacity for assessing the racial disparity of Black jurors. So that really is the task force's main charge. But we've also talked about, kind of, should we expand on a juror questionnaire to not just asking about race, but also about ethnicity, because there may be jurors that identify as a race and ethnicity. And so we really want to, since we have this opportunity to try to look at the questionnaire and get it refined, we really wanted to take a step back and see whether it made sense to add other protected categories, like I said, gender and/or ethnicity. So those are the two areas, the veneer and whether we should go a little broader on our questionnaire, that we would love feedback after this presentation on from other subcommittee members. But that's really what our subcommittee's been up to. So that's my 15 minutes.
Thank you. That's very informative. Are there any questions or comments? You're on mute, Doug.
Claire, I'm Doug Levine. One quick question. Have you discussed in your discussions the possibility or the advisability of collecting information on how lawyers, prosecutors, and other lawyers use their challenges, whether they are accepted or denied, and considered the potentially downside, if you are doing that, effect of that on the ability of lawyers to function freely and represent their clients? I think it's a very tricky issue. I don't know if you're even looking at that.
So to be honest, we haven't looked at that specifically. So we've talked about, what kind of challenge they make on a juror, that sort of thing, and whether that should be collected. But I think we're all trying to balance sort of attorneys' freedom to be able to conduct voir dire, to be able to make challenges to a juror and not worry about all of those things being second guessed. And so I think we're still very much talking about balancing those considerations.
Okay. Thank you.
Sure.
Yeah, I have a question. Should I go ahead?
Yeah, sure.
I was just wondering, when you're talking about amending the form, one of the things that I've come to, I think, anecdotally believe is that some people don't want to fill out the form because they think it's going to actually be used against them in some way. So including maybe in the introduction, something that says we're just doing this for data purposes. And I believe New York actually collects the data, but collects it separately. So there's no name attached to the racial or ethnic data. So thinking about doing that, so people are less reluctant to answer the question.
Those are great suggestions. I'm writing down both of them because I think they're both great suggestions in terms of, and particularly I like the idea of keeping the juror information sheet separate from the data, because that also makes it easier for us in terms of the personally identifiable information issue and really making sure that's only retained for purposes of the appeal and then the actual data collection. So thank you, that's a fantastic suggestion.
Anybody else? Okay, I'm not hearing anything. So next is the juror summoning process. This is Esther Harris and Harry Weller.
Esther, you want me to go forward with this? Since I think we're both on the meeting. Why don't I go forward and then you can augment it as you need to.
Yes, go ahead, Harry. Sorry, I forgot I was on mute.
The subcommittee spent its first couple of meetings just trying to gain insight into the summoning process, what data was produced, and Esther produced a lot of data for us to look at least preliminarily. And also some of the most recent, though it's been a while back, extensive litigation on the issue of the jury summoning process in State versus Gibbs. And then what we did is we brainstormed together to determine specific areas of inquiry that we think will advance our work. And I really appreciate the openness and the ideas that all of our subcommittee members shared. And what we did was we actually broke down, once we figured out what these ideas were, we broke down and gave specific assignments to specific groups. So we have disqualifications and excusals, no-shows and undeliverables, factors that prevent those summoned from serving, a review of Connecticut's process, a review of what other states are doing to ensure diverse panels, and a review of State versus NIMS. And the issue here has to do with the ability to target your summoning process, the constitutionality of doing that. So each one of those groups met and then reported back. The team that did disqualifications and excusal had several questions to explore regarding the impact on jury service. One of the ones that they found interesting was the 70-year-old excusal. You can opt out when you're 70 years old. They found that affected a large number of jurors, and they were wondering the wisdom of keeping it at 70, especially with people being more productive at a longer age, longer in their lives. We don't know how that might affect diversity, but they're going to study that further. Another issue to consider is there's a little difference in the statutes about what constitutes an excusal for prior service, whether it's actually serving on a jury or whether it's appearing in court and being voir dired. I think Esther can probably clarify that, but that was an area of concern that they wanted to explore, and they were wondering whether a 3-year exemption is too long regarding that. Lack of citizenship is another disqualifier, and along with language, it's a major disqualifier for Hispanics. One of the ideas promoted that we will look into is determining whether people who are permanent residents might be included in the process, because many of these people are members of the community. They're certainly invested in the community, and they're also affected by the court system. So that's another area we'll explore. I know nationally, most states and the federal government requires citizenship, but we have other statuses that are very akin to citizenship. They're also going to look into the idea of people who might have lived in Connecticut or have an address in Connecticut, but don't live here all the time, but are domiciled here. Some states will include students in their jury selection process because they spend a certain number of days in the particular jurisdiction. And the question is whether or not that would increase diversity. One area that certainly probably has an effect, though how large it is might be incremental, but still I think it's an important area. We all agree. I think it's a really important area to look for, and that's the exclusion for convicted felons. Number one, whether the 7-year exclusion is long enough. And number two, a concern that people don't know that their rights are restored even when they're eligible for it. So some methodology for making sure that people know that their eligibility has been restored, possibly shortening the time period, and then having a mechanism by which they can do that and be assured that they know. So for instance, if they get a jury summons and they look at it, they'll know whether they're qualified or not and might be more attuned to showing up. The big problem, of course, is no-shows and undeliverables. That was litigated extensively in Gibbs. And some ideas are trying to gather different types of data from our source lists, maybe having emails, texting, get that information as a follow-up to try to encourage people who have been summoned to remind them to return things, and seeing if that technology might help improve responses and also improve actual people, the yield, how many people show up. We understand that CCSD has incorporated this new technology, and we're going to be checking into whether that's increased their appearance rate for people who are on probation or have court dates. Another idea is to provide a letter to the summoned jurors that they can actually give to their employers. A lot of employers might not know the law, but we feel that some laborers may feel intimidated by the fact that they're summoned and really don't know how to deal with it vis-a-vis their employers. So the possibility of something accompanying these summons that they can give to an employer that gives them more comfort with the idea that they can serve and they can't be adversely impacted by it. There is, and Esther could probably explain it, but I think we're going to look at it in more detail, a new system, a new automated system, right, Esther? That's, you're on mute.
Again. Okay, I think I'm off mute now.
Yeah.
So we do have, we have invested in a new system. We are in the process of trying to implement that. And one of the major things that attracted us to this particular vendor was the fact that if we implement the new software that is available to us with this new system, it reduces the amount of undeliverables by 95%. So one of the things that, you know, our subcommittee is going to look at is exactly how this software works, and just delve a little bit more deeper into that and the impact that will have on the undeliverable process.
And I think along with that, I think we're going to try to marry this whole thought with the idea of focusing in on what zip codes. We can even look at what zip codes where undeliverables are higher or lower. And there's a lot of information that can be gathered from the Postal Service about how that affects the summoning process. So we definitely want to look into that, and possibly even look to the summons itself, the package itself, to see if there's anything like that letter I discussed earlier that might make people more likely to respond. This is a personal belief, but I think that some undeliverables are not really undeliverable. I think that people see it and they just don't respond to it, and they put it back in their mailbox because, as one of our experts testified in Gibbs, no good news comes in the mail from the courts for some people. So that's something I think we have to try to disabuse people of and make them more comfortable just looking at it. We're also obviously going to look at what other states are doing in the summoning process, what improvements they're making, and it'd be really nice to be able to find out, it'd be useful to find out whether some of these changes actually produce a better yield. We have a committee the committee that's looking at other states is liaising with the National Center for State Courts to identify what they see as best practices. And we hope that they will be a clearinghouse for information about what the states are doing and what success they've had. The team is also looking into the concept of enforcement and whether that will increase participation. Some states have found that a combination of enforcement and outreach might increase the yield. In the past, when contempt was the remedy for, that was the enforcement mechanism, the state's attorney, chief state's attorney, tried to enforce the summoning process, and it really created a impractical and really impractical response. So there may be some type of combination of enforcement and outreach that might help at least get people's attention and make people be more willing to attend. As far as NIMS goes, you know, one of the experiences that we had in Gibbs was that a federal magistrate was basically, when she felt she wasn't getting enough of a yield of minorities because of the whatever factors caused that, she would send additional summonses focused at certain areas where minorities, according to the census, lived. And in Connecticut, and I think in most states right now, that's considered an unconstitutional manipulation of the system. NIMS basically held that any intent to stack a jury panel by intentionally including or excluding any members of a discernible group runs afoul of both due process and the right to a jury trial. But still, the idea of trying to remedy this by more outreach into certain communities, I think it's something worth looking at. The legal concept has had some success depending on the purpose for any type of focused on a particular group, what's the reason behind it and how it's done. And before we reject it out of hand, I think the group thinks it's worthwhile to look into it. So we're doing research in that area. And that's what I have. Esther?
I have nothing to add. Thank you, Harry.
Oh, excuse me, there's one more. There's
You had nothing to add because you took all over time, Harry, just so you know. I was keeping track.
You're good. Are there,
I always trust Justice Rogers for telling me
there
whether
you
I'm
go.
doing it. Because she was always the very good clock keeper. The other issue is facts preventing service. This is an issue that could be very tough. I mean, we know that, for instance, from studies in Gibbs, that things like not having a car and not having childcare were definite reasons why people didn't participate. Getting data on that, we are trying to talk to people who actually have done outreach for the jury administrator, anecdotally, to find out what reactions people have had. But this is going to be a harder nut to crack, because to actually gather the data and analyze what people are concerned about regarding actually showing up for jury service and how we might remedy it, including compensation, but we are looking into it.
Okay, that's great. Any initial questions or comments?
Yes, this is Preston Tisdale. I thank you. I do have one question, which Esther and Harry have both heard from me before, and it's a conundrum that we've never been able to quite figure out. And that conundrum is this: prior to Connecticut going to the one-day exposure for jurors, the Fairfield JD was one of the pilot jurisdictions that engaged in that particular process. There were several jurisdictions. Fairfield JD was one of the pilot. Prior to that time, you know, people had a month's exposure. And it tended to be, certainly at the Fairfield JD, you had some of the most non-diverse panels that were not representative of the community at all, which would come in to the courthouse and be part of your panel that you would select your jury from during voir dire. When we went to the one-day pilot program, suddenly we had some of the most diverse panels that I had ever seen in all of my practice. Prior to that time, most of our persons could double as, or if you would say, Archie Bunker brothers. You know, it would be a panel of folks of a certain age, of a certain mindset, who were very unhappy that this was their 25th day and they were being called, and it really had a chilling effect on, you know, trying your cases, certainly in terms of the confidence that your client had in the fairness that they would receive from the jury. But it was profound. It was a profound shift. You had these incredibly diverse panels that came to the court. Now, over the years, that has eroded. And while it hasn't gone back to the pre-pilot days, we've never been able to figure out or put our finger on what it was that has caused that erosion, what it was that caused that sudden burst of diversity. And it would be just wonderful if we could get to the bottom of this, figure this out, because it may provide us with a very important answer.
I think that's very insightful, Preston, as always. It would be wonderful. I was wondering if there's any way to go back and look at that data, give us an idea of the, and see how the change occurred, and then see within the data whether there's anything we can identify there first. Because sometimes it's change in mobility, and some of the things we just don't know. But that's an insight that I would love to be able to put a finger on it, because if you find the reason, you may find that there is a response that would be useful. So we'll try to brainstorm that one. That's a real good idea.
So one suggestion I have about that also would be to talk to Joe DeLessio, who, first of all, was the Fairfield JD, and he may have some anecdotal understanding of what happened, or at least point you in the right direction.
Great, thanks.
Thank you.
If I could, I would love to just make a brief amplifying comment on Harry's remarks, if that's okay.
Yes,
Sure.
absolutely.
So I just wanted to comment briefly on Harry's reference to some of the potential constitutional restrictions on changing some of the ways we do jury summoning. I've been doing some research, and I agree with him. I think, any process that specifically reaches out and targets voters of any protected category or attempts to discriminate for or against them in that way is unconstitutional, and NIM says that, and Gibbs discussed it as well. On the other hand, there's definitely I've been doing this legal research, and there's definitely ways to adjust the juror summoning process in ways that increase diversity without, again, targeting people based on their status or background. And so I think one of the challenges that the subcommittee will continue to focus on is how to thread that needle and make sure that anything we recommend on that point does abide with the constitutional limits on that process.
I like that notion of thread the needle, because that's what I'm trying to do with the research, is find out where the hole of the needle is, so we can. So we're in agreement on that. The subcommittee is certainly on agreement on that. Thank you.
Okay, another question, Doug?
Yeah, very briefly, Harry, it seems to me that all of these issues are very, very important, but I cannot tell you how many times I've been at events where people approach me as knowing I'm a judge and ask me, how can they get out of jury service? I mean, it happens all the time. People do not want to sit on a jury. And so it seems to me that one of the potential things to think about is, I don't know how it would be accomplished, but public service announcements or something that would get the idea to the community and to all parts of the community that serving on a jury is not only a burden, but and a civic responsibility, but that by doing it, you are contributing to the fairness and the justice and the racial justice of our system. Has that been something you've talked about in terms of trying to make changes in attitude, as difficult as that might be?
Well,
So I'd like to be able to answer that, because we have created a PSA, and we're currently working with External Affairs. I believe we're in the very last stages of implementing it. I know that we have the language put together. We've identified some of the radio stations that we need to implement this PSA to. But we have created a PSA, and it's just a matter of finishing implementing that as far as our outreach program goes.
And Doug, there is an outreach committee that specifically, one of the subcommittees is dealing with that. Historically, the jury administrator has actually had an employee that went out to schools and went out to fairs and things like that to talk to people, to persuade them of exactly what it is you're discussing. I think that we'll probably overlap and talk to the outreach committee to see if there are ways to make that more effective.
Thank you.
Can I just add one more thing? I'm sorry, I do agree with you because we have heard, I've been out as jury administrator, I've been out to many communities and you are correct when you say that people just don't want to serve. But I want to remind us all that particularly in Black and Brown communities, part of the problem is the perception of the criminal justice system that that our communities have. And I think that's a very big piece of, winning hearts and minds, if you want to call it, that to get people to want to be part of a jury. It's a very, very big problem. And I think it's something that we will have to really find resources to have an impact and get, I don't know how we do this, but how we get people to view serving on a jury as, their right and a favorable thing to do.
If you're doing any outreach, I'd be happy to help. Just let me know.
Thank you.
Okay, any other questions or comments to this subcommittee? All right, great. So we'll move on to the implicit bias. Not sure who's speaking.
Okay. Yes. Dave Gold and I are the co-chairs of this, and Dave, I invite you to add anything you want while I'm speaking. I want to just very briefly begin by saying that we have honored all views that we've heard, and we're having very good, interesting discussions. A lot of people have done a lot of serious reading of law review articles and other scholarly material. And we are meeting frequently, as I'll explain. We broke down into working groups. Dave and I are trying to attend all of the meetings if we can, just so somebody, has an overview of what's going on. The charge of our group is extremely broad. And just briefly, I'll read it. This subcommittee will study the extensive body of work relating to implicit bias and its impact on the jury selection process. Implicit bias is everywhere, and it exists both inside and outside the jury box. How does implicit bias impact our jury selection process and ultimately the jurors who are impaneled? The subcommittee will examine how the court can play a role in addressing implicit bias through the use of peremptory challenges and the creation of model jury instructions. And it goes on, but we're dealing with something of broad societal and psychological and political and you name it, and legal ramifications. What we decided to do at the start was basically take our committee and break it into 3 different working groups. Group 1 focuses and is focusing on peremptory challenges. Dan Krish, Chris Rapillo, and Tobachukwe Umwego, I hope I didn't butcher that too badly, and Dan Krish are on that committee. The committee 2 is the Batson Challenges Committee. Joette Katz, Rich Colangelo, Preston Tisdale, and Anya Goldsby. And group 3 is focusing on model jury instructions. And again, that's Dan Krish and Professor Neil Feigenson from Quinnipiac. I think the most efficient and economical way to go here is for me to simply ask we have spokespeople for each group. And I think if they give brief summaries of what they've been doing, that's the best way to go. So on the peremptory challenges group, who's going to be the spokesperson on that group? Is that Dan? I think we sent out an email asking you to pick someone.
It is me.
Dan?
Yes.
Okay, then would you mind giving a brief report on what you have been doing and how things are going?
Sure. So I'll begin by saying that the full subcommittee quickly concluded that there was potentially a lot of overlap between our work and the Batson Challenges Working Group's work. And to make sure that we didn't step on their toes and reinvent the wheel, we limited our focus to what, if anything, should Connecticut do about the number of peremptory challenges in criminal and civil cases, including just the number absolutely, and then should there be in criminal cases, should there be an unequal number between the prosecution and the defense, and also as a sort of separate but related issue, what should we do about whether judges should preside over a civil voir dire? We are, I should just add that Neil Feigenson, Professor Feigenson, is also in this working group. We are in the process right now as a working group of finalizing a draft report, which we're going to send to the full subcommittee to review. But our conclusions have already been discussed among the full subcommittee. Obviously, or not obviously, Connecticut has a unique constitutional provision that gives the parties the right to peremptorily challenge jurors. There's no federal constitutional right. There's no other state that constitutionalizes that right. So we fairly quickly decided that eliminating peremptory challenges entirely, although there is some scholarly work that supports that notion, and there is some marginal empirical data to support that idea, is a non-starter. First, it's arguably beyond the charge given to the task force, which is to look at statutory and rule changes, not convening a constitutional convention. More importantly, the notion of eliminating peremptory challenges would, we think, engender enormous opposition from the bench and the bar for various reasons. I can only imagine how the CTLA would react, given how they reacted to the notion of eliminating individual voir dire. And they are certainly not the only group that would get up in arms about it. Also, peremptory challenges, although they have the potential for resulting in racially disproportionate jury selection, they do serve some useful functions. They give the parties and their lawyers a sense of control over the proceedings. They are a check against the judge being the only one to decide on fitness for jury service. And our draft report has other reasons, but they're not just a bad anachronism that needs to be gotten rid of. They have use and value still. So even if we wanted to recommend convening a constitutional convention, which we don't, there's very good reasons to retain peremptory challenges. Nonetheless, there is a significant body of scholarly work about the problems with peremptory challenges and the ease with which they can be a gateway for implicit bias come to the jury selection process. So we looked next at, within the framework of Article 1, Section 19, what, if anything, can and should we do about the number of peremptory challenges? And that was a thornier and closer question, I think, than eliminating them. Right now, our preliminary conclusion is that we should not do anything about the number, either as an absolute number or making some distinction between the prosecution and the defense in criminal cases. And some of our reasons for that are the same as our reasons for not eliminating peremptory challenges entirely. They have a useful function. We would again anticipate a lot of opposition from the bar and the bench because of the deeply rooted nature of peremptory challenges to any change to the number. And in terms of differentiating in criminal cases, there might be a constitutional issue with that as well, because the language of Article 1, Section 19 says the parties shall have the right to peremptorily challenge jurors, the number to be set by law. It doesn't, at least facially, provide for a distinction between one party and another in one case in terms of the number that they can have. So Connecticut, it turns out.
Dan, I'm really sorry to interrupt, but our whole group has 15 minutes and we have a lot, and I apologize, but I think we want to go on to stay within our time period if we can.
Sure, so I'll finish up in 1 minute. So
Thank you.
the National Center for Reports has a great database. So Connecticut actually is at the very low end on the number of peremptory challenges, except for capital cases, that it allows in criminal cases and sort of in the middle in civil cases. So we are already not, a statistical outlier giving tons of peremptory challenges. So to the extent that there is any marginal gain in terms of reducing implicit bias, A, there's not much room to work down, and B, there's almost no data or scholarly work to quantify what sort of gain you would get in terms of reducing implicit bias if you went, say, from 6 to 3, right? There's nothing to empirically support that change. So we're working on our draft report as a working group, and that's all I have on that.
Thank you. And by the way, what we're doing is we're going to ask each working group at the end of their work to submit a written summary and report to our full committee, and then we're going to take a position on that and pass on our recommendations to the full task force. The second group is the one that deals with Batson challenges. Obviously, this is a very meaty and very important subject. I can't recall if Rich or Joette were going to report on this. Rich, are you doing this, or is Joette?
Actually, Preston is.
Oh, well, excuse me, Preston, I apologize. You're the reporter on this, then please, please report.
Not a problem. Actually, I'm filling in for Joette because where she's located, jets keep flying above her and the noise factor. But I'll try to, do a little bit as good as she would have done. But the bottom line is we had a very robust discussion and really consideration of the factors that involve the Batson prongs. I can say that the discussion was to a great degree driven by the Washington 37 rule, had a great impact on our discussion because what we realized was that the neutral reasons that were given once the Batson challenge was made were pretty much illusory. And what it did was render Batson pretty much a toothless remedy. So in terms of what we talked about, in terms of the Washington rule, they incorporate implicit and institutional and unconscious biases into the process of the consideration. They also deal with an objective observer standard. And as I said, it combats the common race neutral reason, which are often given. We also discussed, in addition to adding the discriminatory impact, that to be considered both at the prima facie level, but certainly at the determination level by the court. And there was, obviously, we didn't get to a determination as to how that would exactly be constructed, because there's a lot more discussion which has to take place and a lot of more consideration. In terms of data, there were certain objections which were raised in terms of, well, what kind of data, how long standing, how long back, how far back would such data be considered? But it was realized that while that would not give an immediate solution to the issue, it does provide and it elucidates aspects of discriminatory usage of peremptory challenges which can be combated. Of course, the court has ruled that even a single discriminatory exclusion is unconstitutional. So we're not losing sight of that fact as well. So we were weighing and considering both the single discriminatory exercise of peremptory exclusion as well as the systemic aspect, which would only be determined by data. And with that, I'd ask that the remainder of our committee chime in because we, as I said, we had a very robust discussion.
Well, thank you. This is obviously a huge topic, and it's fascinating, and we have some different views, but we'll see if we can come to a consensus. Finally, Group 3 is focusing on model jury instructions. The members are Dan Krish and Professor Feigenson. Is Professor Feigenson, are you the spokesperson, or is Dan doing it?
I am, but I'll be succinct.
Go ahead.
It's you.
Thank you.
Or more succinct, I guess. So Neil and I divided things up. He took the scholarly and empirical study end of things, and I looked at what other states and other jurisdictions do. Connecticut is in the vanguard, happy to say. Only 8 other states and the Ninth Circuit, some of the district courts within the Ninth Circuit have model or required instructions that specifically address implicit bias. Connecticut's is a very recent vintage and very good. What we did was we focused on a couple of discrete areas where we thought we could make something that's very good a little bit better, because this is a new and evolving area. So one is a few tweaks to the language based on recent psychological and empirical research about what are the most effective ways to keep jurors' minds open to the concept of implicit bias. For example, depersonalizing it, analogizing it to, reflex reactions when you go to the doctor and they test reflexes, things like that. And so we're looking at just a few minor additions to the language that's already there. Then the other 2 things we're looking at is, one, what points in a case should such an instruction be given? Quite a few jurisdictions give some form of the charge as part of the opening instructions to an impaneled jury. Because if the point is for jurors to keep their minds open and check their implicit biases, you want them to be doing that while they're hearing witnesses testify, not at the end when they go into the jury room. And so quite a few jurisdictions that have these give some form of it as part of the opening charge, as well as a lengthier version of the final instruction. And then should it be given in civil cases as well as criminal cases? Most jurisdictions do so. Most jurisdictions that have an implicit bias charge give it in both civil and criminal cases. Connecticut doesn't. Illinois oddly gives it only in civil cases. But we're looking at that as well. But as I said, we have a great foundation to build on, because there is very good language already in Connecticut's model criminal instruction. And so we hope to report back to the full subcommittee soon.
Great. Thank you. That's pretty much it for us.
Okay, before I ask any questions or comments on the last discussion about the model jury instructions, I want to make sure that you all got the work that Hillary Barger DeCrancis had done on this very recently, looking at the civil side too. Is that sounding familiar?
Yes,
Okay.
We did.
All right, good. And you should feel free to contact her. She's in judicial education now, to the extent she can be of help to you. Okay, great. Any questions or comments about this group? All right, I believe that leaves us with juror outreach and education.
Hi, good afternoon. Our committee is reviewing the jury outreach program, and we've held 2 meetings and are focusing our efforts on how to effectively partner with community organizations from the minority communities to encourage jury service. We're also focusing on the role of the community colleges and universities and how they can play a role in educating the individuals about jury service. The subcommittee is trying to identify resources needed for an outreach program that specifically targets minority communities, because we feel this is an important component of the jury process. As has already been noted, this afternoon, there's a lot of misinformation and negative perceptions about the criminal justice system, and that can impact whether or not an individual will actually show up for jury service, particularly those individuals from minority communities and those with the limited English proficiency. So we are reviewing all of the current documents that are used in jury administration, and we are preparing suggestions and updates so that the jury process becomes really more friendly and less scary to individuals who are summoned to court for jury service. We have discussed having attorneys offer pro bono or community service hours to explain jury service to community groups. We've discussed how to engage community groups to address trust issues with the court system. We're hopeful that the Affinity Bar Association and other community organizations can help us with ideas on how to engage the community through either events, posters, brochures, or any better marketing about jury service so that we can improve the diversity in our jury panels. So we've talked about having speakers go out, how to advertise, and really the need for flexibility in reaching different members of the community. That might include having evening and weekend hours for community meetings. We believed in order to improve our outreach, again, the documents used in the jury administration needed to be friendlier and easier to read. All of the subcommittee members are reviewing Your Guide to Jury Service, as well as the other jury brochures, and they are making positive suggestions for changes. Some real nuts and bolts basic things that we've discussed are that, you know, each jury brochure should have that QR code so that people can access it more easily. Ensure that all jury documents are cell phone friendly. To consider the expanded use of social media platforms to spread positive and vital information about jury service and the court system, and to help draw more of the public to the judicial branch website. And on the website, we thought there should be photos and brief write-ups about judges or staff members, community events that might be being organized, to provide some facts about the court system, and again, to teach the people who access our system the entire process in a simple to read and interesting way. I did not realize that the PSAs were already being reviewed, but we thought that there should be more real-life testimonials from jurors who had served and found it to be a positive experience, and PSAs specifically about jury service, and also to engage other state agencies to provide a link to our website so that more information about jury service could be circulated. We believe the information about stay-at-home parents and caregivers needed to be given a more prominent place on the website, including the qualification for disqualification, because it's difficult to find. And when you do locate it, if you are a stay-at-home parent or caregiver, you really can't determine if you qualify when you complete the form. So, you know, we looked at very specific parts of the jury administration and the process to see if that can all be part of the outreach. Things like improving the links regarding parking and where are the closest bus stops and restaurants and other relevant facts if you do get called to jury service, and to visit the new citizen groups, community organizers, to attend town meetings, and try to get them vested in a jury service. So we're looking to identify and educate community leaders and college students to help get out the information about the importance of jury service and why it is important to diversify the jury pool. So a part of our charge has been to reach out to all of the law schools in Connecticut, including the student governments, because again, the subcommittee believes it's important that younger individuals embrace and endorse jury service. We have, and I think Esther knows this, outreach to the high schools, and we would like to see that expanded because it is a good entry point for the message to get to members of the community to want to serve as jurors. And other things that we've discussed is to continue to hire and train a more diverse jury staff, to again maybe specifically try to reach out to the 20, 30, and 40-year-olds, these young professionals and parents who are busy with a lot of other things in their life. How do we convince them about the importance of jury service and their need to participate in this process? And finally, to reinforce the importance of jury service in our brochures and messages by providing these in multiple languages. I really would like to commend the subcommittee for the efforts that they've made. Charlene Merced Augusto, the co-chair, she has been completely instrumental in bringing topics into focus and guiding the subcommittee to workable goals and solutions. And Sherry DeLuca from Jury Administration has given us the nuts and bolts of jury service and made all of the documents available to the subcommittee so that we could provide concrete methods to improve our jury system. I'm going to shout out to Hannah Kogan, our student from UConn Law School. She has offered to meet with the presidents of the Black and Latino law organizations, as well as numerous professors, to engage and educate those communities about our outreach effort. And finally, Scott Esdale, the president of the Connecticut NAACP, has indicated that his public relations team is willing to get together with our subcommittee members to discuss effective outreach in the community and help produce the messages and the brochures and posters that could have a positive impact in the community. Connecticut NAACP already has contacts established at all of our state community colleges and colleges, so they are willing to partner with us in our outreach effort. And I am very thankful for all of the support that these individuals have given and their contributions. Charlene, did I miss anything?
That seems very thorough, so nothing else.
Okay, before I turn this over to Judge Williams for whatever he would like to say, I did have one thought as I was listening. I had two thoughts, actually. One, it seems like everybody is really on track, and this is going to be extremely helpful and productive. I'm wondering, we're talking in a theoretical world right now because there is no such thing as a jury trial given the pandemic. And I don't want, and I'm sure nobody wants creep here, but I'm wondering if the chairs and their subcommittee should be thinking a little bit about whether there's anything to do with the pandemic that they want to give some thought to in terms of what their recommendations are. We'll talk about that with the administration, and to the extent that they're interested in that or think that that is necessary, we'll get back to you with something more concrete. But that did come to mind as I was listening. So, Judge Williams.
Chase, Chase, before you turn it over to Judge Williams, this is David Gold.
Yep.
There is a lot being done about starting jury trials, and it's going to be sooner than you might think. There's going to be some public service announcements made very soon by way of an op-ed piece. And we're dealing with Esther, who's been wonderful. We're sending out, as we've developed a new COVID-based form so that we can address those concerns. The Chief Justice is going to be commenting on those things in his op-ed piece. And I think we're hopeful that before the year's out, there will be jury trials.
Okay, that's extreme. That's very helpful.
Okay. You're very welcome.
All right, Judge Williams, do you have anything to add?
Hi, I'll keep it very brief, given the time. I just wanted to thank all you guys. You're all doing tremendous work already. Each of you is here for very good reason, and I know that your work outside of the task force has been incredibly challenging. And despite that, you've done amazing work here as well. So I just want to thank you for your service, both there outside of the task force and here. It's clear that you've done a lot of research and brainstorming, and you've thought long and hard about not only your specific charge within your subcommittee, but overall, what you would see as success in this opportunity. And I just wanted to thank you very much for the incredible work that you've been doing, and hope that you enjoyed the very well-deserved Labor Day weekend as well. And thanks for taking your time so close to it. Thank you, Justice Rogers.
Okay. Any other questions or business before we depart for our long weekend here? All right, again, I just want to thank everybody, and we'll see you in about a month. So again, thank you and have a wonderful weekend, and please be safe, everybody.
Thank you.
You too.
Have a good day, everyone.
Great to see you all.